All right, well, welcome to the webinar on the probate process. My name is Matt Parker. I'm one of the attorneys with the law firm of Marshall, Parker & Weber. This is going to be a webinar on that rather confusing process regarding the settling of the financial affairs of a deceased person, often called probate. So some of the questions we're going to answer today involve when is probate required, what are some of the steps you need to take, and do you need a lawyer? Now, keep in mind, there's a lot to settling an estate. We obviously cannot answer each and every question that's going to come up in an estate. Every case is different. So what I'm going to do today is present a more general overview of the various issues that come up in an estate so you have an idea of how the process works. Now, you can ask questions as you go along. There's a way to actually enter a question, and I'll try to get those answered by the end of the presentation. All right, so let's begin the content. So what is probate? Well, probate's that court-monitored process associated with administering the estate of a deceased person. It is through this process that an executor, or in some cases an administrator, is appointed to handle the duties associated with settling the financial affairs of the deceased. Now, there are a whole host of tasks that go on in the probate process. It involves the collecting of the assets owned by a deceased person, paying the debts, including any inheritance taxes, and then eventually distributing the assets. Now, probate has often been used in a general sense, to describe the settling of a deceased person's affairs. However, the very specific definition involves the local court, usually through an office called the Register of Wills. So if there is a will, it is produced and given to the register, and the executor is officially given the authority to carry out the duties. Now, during this probate process, there is a record of the executor's activities that are recorded in the local court. Now, at the end of the process, there's often an accounting that's provided to all the beneficiaries, showing all of the financial transactions that went on in this probate process. At the end of probate, the estate is officially closed, and there's usually a settlement agreement or a formal accounting process to wrap up the affairs. Now, probate can take some time, depending upon all the various issues involved. Some estates are rather complex due to the number of assets or maybe the number of creditors. Perhaps there are some assets that are very difficult to sell, and there tends to be delays in resolving the estate. This often happens with real estate. In other cases, there are disputes that need to be resolved, often with the beneficiaries. So I tell my clients, expect in most cases that the probate process is going to take over a year to complete. Now, in many cases, probate is not required when a person dies. Probate is typically required when a person dies owning an asset where ownership cannot be passed onto a beneficiary without court involvement. Many accounts, real estate, and investments pass on to beneficiaries via a contractual agreement that will not require probate. For example, let's take a life insurance policy. Life insurance is a contract that has a beneficiary named to receive the proceeds. There is no probate required to receive the proceeds of life insurance. A beneficiary needs to advise the insurance company that the insured has died, send along a death certificate, complete a beneficiary form, and then receive the proceeds. This is the same process for other beneficiary-driven accounts such as annuities and IRAs. Some assets are jointly owned, such as real estate and bank accounts between a husband and a wife. For that reason, we rarely see probate when one spouse in the marriage dies, provided the assets are held jointly with the right of survivorship, or they are the beneficiary of one another's investments. The assets pass to the surviving spouse without the need for probate. Now, some people also have a trust, whether it's a revocable or irrevocable trust. A trust has its own beneficiaries and typically avoids the need for probate. Now, most people who have a trust also have a will, as not everything they own ends up in the trust. So don't presume you need to go and probate when somebody dies. Look to see if there are assets or accounts where nobody else is listed as a co-owner or as a beneficiary. In most of those cases, the only legal option is to proceed to probate. Now, I do want to mention two items that come up a lot where probate is not necessary. We will talk in a moment about the details of the probate process, but understand there's a fair amount of work involved in probating an estate. So we would rather not probate if there is a very small bank account or nothing more than an automobile owned by the deceased. So there are ways to get around probating if you have one of these assets. Now, the small account statute allows banks and similar institutions to pay up to $10,000 to family members of a deceased person, provided there was proof that payments had been made for funeral services. So if you are a spouse, a child, a parent, or a sibling, you can visit the bank and close out the small account with a funeral bill that has been paid. In fact, the bank will turn around and issue a check directly to you. Now, if a funeral bill has not been paid, the bank will usually pay the balance in that small account to the funeral home directly. Now, with the automobiles, the Department of Motor Vehicle has a system of transferring ownership without the need for probate. The Department of Motor Vehicle Form MV39 is used to transfer title without probating. Keep in mind, you have to be one of the listed beneficiaries in that form to use this process. In some cases where there are multiple beneficiaries in a will, you'll need all of them to sign off to have that vehicle transferred to one of the beneficiaries in the will. Nevertheless, these are two provisions in Pennsylvania's law that often allow us to avoid probate when we have very limited assets. So let's presume there are assets in the deceased person's name alone. You need to probate because there's no other legal way to transfer ownership of the assets to another person. Now, the first question, is there a will? If there is a will, you need to locate the original. The original should be signed by the deceased and have two witnesses. If it is not notarized, you're going to need to locate the witnesses, and they need to appear before the register and give an oath that they saw the deceased person sign the will. Now, if there is no will, the estate will proceed under what is called the intestate process. These are a series of provisions in our probate law that determines who will administer an estate without a will and who will be the beneficiary of the estate. Now, if the deceased was married and had children, they, of course, will be involved in this intestate process. If the deceased does not have close family members, it may become more challenging to find an administrator to distribute the estate. Now, the will is taken to the Register of Wills by the executor. The executor needs to appear in person and then take an oath in the register's presence. If there is more than one executor, they both need to appear. A petition is prepared and filed with the Register of Wills along with a death certificate. Now, the petition for probate is a standardized form that lists information about the deceased, the beneficiaries, and there's some general information about the size of the estate as well. There is a fee that the register will charge to open the estate. In Pennsylvania, this is a flat fee that is charged at the time you file the petition. It is based on the size of the estate. Once you are officially appointed as the executor, a document called Letters Testamentary is issued by the register. Your official appointment is evidenced by a document called a short certificate. This is the document that can be used to close out bank accounts, sell cars, stocks, and sell real estate. Letters of administration, however, will be issued when there is no will. There's no rush to probate an estate. Normally, this is done in the weeks or months after somebody has died. It's typically done after the funeral is held. Too often times we see family members trying to rush to see the attorney's office in the days after somebody dies. And this, of course, is not necessary. Families should take care of the funeral and other matters first before they visit the attorney. Now, nobody can force you to serve as an executor. You may have been named in the will, but you can always renounce or otherwise step down as the executor. Hopefully more than one executor has been named, and there is somebody willing to take over if you do not want to serve. Even if there is a vacancy in the will, there's a state law to determine the order of succession in the event of a vacancy. Now, being an executor is a lot of work. The work is based in part on the type of assets the deceased person owned. If everything is in a liquid form like bank accounts, those estates are easier to settle than those with physical assets such as real estate and cars. As I mentioned, the time to probate can be over a year in a typical estate. If you add dysfunctional relationships in an estate, your time and stress can multiply. Now, you are entitled to a fee as an executor. It's generally 5% of the probate assets in the estate. Now, it is income to you, therefore you have to report it on your tax return. So keep in mind, if you are one of the beneficiaries in the estate, some of your inheritance will now become income taxable to you if you take a fee. Now, you are not personally liable for the debts of an estate. Think of an estate as an entity that is formed after a person dies to collect the assets of the deceased and then pay the debts. It will have its own employee identification number. As an executor, you are the manager of the estate. You can decide, for example, how much to sell the car for, or maybe the real estate. You can have an auction as well. You can decide whether to pay the debts or dispute some of them. You can also collect money that is owed the estate. Now, you have to do your job properly. You cannot behave in a negligent manner. If you act in a manner that harms the value of the estate, you can be surcharged. This is a word for an action for damages due to your negligent behavior. In some cases, executors will get insurance bonds to protect themselves from these claims in particularly large estates. So you need to think carefully before you decide to become an executor. Well, this may sound like a self-serving part of the presentation, but there are very good reasons why most estates involve an attorney. There are issues that you will encounter in a typical estate that you simply cannot answer. It happens all the time, whether it is dealing with taxes, creditors, or beneficiaries. You may end up saving yourself some time, money, and aggravation by having an attorney help you with probate. Most people will be involved in an estate once in their lifetimes. Why should they bother trying to figure out all the rules, the court filings, deadlines, and taxes when you can pay somebody to help you who knows the process? Working with an attorney can also help avoid the possibility of a surcharge claim. I am blessed with having some great support staff at Marshall, Parker & Weber, particularly the case managers who help me with estate administrations. They, of course, are in constant contact with the executors, helping to address the many, many issues that come up in these estates. Now, as the probate process begins, you need to keep in mind there are some court filings that are required. First, you need to notify all the beneficiaries that they have an interest in the will. They are entitled to a copy of the will. Once you notify them, you need to file proof of that notification with the register. You also need to publish a notice of the estate in the local paper and, in many cases, the local legal journal. This legal advertising appears once a week for 3 weeks and gives some information about the deceased and a contact person, such as the attorney. The purpose is to give creditors the right to come forward and present a claim with the estate for that debt. Now, a year after the first advertising, creditors will be prohibited from presenting a claim. So this process can be very crucial in some estates. Lastly, there's an ongoing status report that has to be filed. The register and interested parties are entitled to know the status of the estate administration. Now, here are the principal activities of an executor. First, you're trying to identify the assets of the estate. When you start this process, you will realize that the first challenge is trying to determine what the deceased person owned. What accounts did they have? What banks? Did they have investments, bonds, cars, personal property, real estate, and so on? Just collecting all of that information is a time-consuming process. Second, you need to protect the assets of the estate. You are tasked with managing an estate for the benefit of the beneficiaries. You cannot allow a car to be stolen, a house to be vandalized, or personal property to be taken before the beneficiaries have an opportunity to choose those items. So you make sure there's fire insurance. And keep in mind, those policies tend to expire 6 months after somebody dies. You need to make sure the cars are garaged and insured. You need to make sure nobody has access to the house but you. Change the locks if you have to. When it comes to investments, you often need to sell the stocks to avoid that big downturn in the market. Keep in mind, you're not obligated to make money for a beneficiary, but you shouldn't be losing sizable amounts of dollars. So typically, investments are liquidated shortly after the deceased person dies. Then you need to value it all. Some items are easy to value, such as getting date of death values for bank accounts and investments. Cars, they need to be appraised by a car dealer. Houses can be valued when they sell, but you can also get an appraisal. Personal property can also be appraised. However, in some cases, it's not worth all that much, and executors do have some leeway to decide how much it's worth if an appraisal is unnecessary. Pay the debts and expenses. This could be with existing debts, such as credit card bills, or ongoing expenses, such as those with the house. Income tax issues are big in some estates. There are tax returns that sometimes have to be filed for the deceased, and returns that have to be filed for the estate itself when transactions result in taxable income. Finally, the executor is going to dispose of the assets of the estate. During the administration, assets will have to be sold, such as real estate and cars and so on. Then eventually the estate is distributed to the beneficiaries. Each beneficiary is going to get their share of the estate and sign off on the executor's work. Now, during the course of the administration, a Pennsylvania inheritance tax return will have to be filed with the Register of Wills. A Form 1500 has to be filed within 9 months of the decedent's death unless a 6-month extension has been requested. Now, the rate of tax varies depending upon who inherited the assets. Spouse is at 0%, while children and grandchildren are at 4.5%. If you're a sibling, it's at 12%, and all other people, 15%. Of course, if there are charities, they are at 0%. Now, you can make an early payment within 90 days after the date of death and receive a 5% discount on the amount of inheritance tax paid. Now, inheritance tax returns can also include those non-probate assets, such as IRAs and jointly owned accounts and gifts that were made within a year of the date of death. How the tax is paid on these other non-probate assets is dependent upon what the will says. Often there is something called a tax clause in the will that explains how the inheritance tax is paid on the non-probate assets. In many cases, they are paid out of the probate estate no matter who inherited the assets, via the probate process or the other non-probate means. Now, estates should not be settled until the Department of Revenue approves the inheritance tax return. It can take many months for the Department of Revenue to approve a return. Now, you may be the executor of an estate where a percentage of the money goes to a charity. It could be a church, a school, or some other charitable organization. When it comes to charities, there are rules in place to protect their interest. A division of the Attorney General of Pennsylvania must be notified by the executor that a charity is a beneficiary. The Attorney General will review the work of the executor and how much has been charged for fees, including the attorney's fees. The Attorney General's role is to ensure that the charity gets the funds that they are owed. It is not unusual for the Attorney General to reduce executor and attorney's fees if they're not in line with the fees the Attorney General considers reasonable. Well, eventually your work as the executor will come to an end. Once the assets have been liquidated, the executor wants to give the beneficiaries their share of the inheritance. An accounting will be prepared, setting forth the value at the date of death, the liquidation value, and the amount now available for distribution. This accounting also has a list of the debts paid and the expenses of administration, including executor and attorney's fees. The beneficiaries will review the accounting and agree to accept it via what is called a settlement agreement. Once it is signed, the beneficiaries will receive their share. In some cases, this informal settlement agreement will not be signed by the beneficiaries. Perhaps there are more creditors than estate assets to pay them. Or maybe there are many beneficiaries in an estate, making the informal settlement process too cumbersome. A court accounting can be filed in these cases. In this accounting, a notice is sent to the beneficiaries that if they object to the accounting, they have to file a notice of their objection with the local court by a certain deadline. If they do not file an objection, the accounting will then be approved by the court. Now, with either one of these systems, the work of the executor comes to an end once the accounting is approved. There is a final status report filed with the court that the estate administration has now been completed. Well, that covers a variety of the issues in a typical probate process. There may be some articles of interest to you on our website regarding estate administration or other matters. So please visit paelderlaw.com for more information. Thank you for attending.